You may be seated. Okay, let the record reflect that the defendant is present along counsel for the defendant, assistant state attorneys. All right, y'all ready to proceed with the charge conference?
Yes, sir.
We will start with the standard jury instructions, and then we will proceed when we get to instruction to deal with requested jury instructions. Okay, introduction to final instructions. Any objections to that instruction? Defense? Part?
Correction to take out what we did yesterday.
I believe that's the next page.
Pardon?
That's the next page.
Okay. I'm going off of what I gave you. That's what we will work from, and we will make any additions or deletions.
Yes, sir. There's no objection to the first page.
Okay? Introduction to homicide.
Your Honor, I believe we've discussed it and agreed that aggravated manslaughter of a child would not be a lesser included offense of count one of murder in the first degree. It is a separate count, but we all agree it should be excluded, eliminated as a lesser of count one.
Right. Have you fashioned an instruction then to tell the jury they cannot find the person guilty both of aggravated manslaughter of a child or murder in the first degree?
No, Your Honor, because I don't believe that, I believe the jury can find the defendant guilty of both counts. And if aggravated manslaughter is considered a lesser, then the court cannot sentence and adjudicate on both, but the jury can still find verdicts on both.
And what case authority do you have for that proposition, either the state or the defense, since you seem to agree?
Judge, I'm not aware that it's a disputed issue, so I don't have any case authority.
Well, the reason why I say that is because in earlier conversations, and the reason I put it in there the way it is, was because in talking with lead counsel, the reason it was charged that way was because it contained elements that was not contained in the indictment that could not be included as a lesser included offense. Thus, you needed to charge it. So what is it that you propose?
I believe.
I tell you what, did y'all redo all of the instructions and provide them in writing?
I'm sorry, did we read?
Did you read, since you decided to change things you have preliminarily told to me, I will assume that you have done them from soup to nuts in writing.
No, sir,
Well, you better get somebody to do them then.
I'm sorry, Judge, I wasn't aware that you wanted us to redo them, but
Well,
we'll be happy
no
to.
one told me.
I'm sorry, I think we were all under the mistaken impression.
Yeah,
I'm sorry.
I guess y'all were mistaken. So I will wait to do the charge conference at noon when you can provide me, since y'all have agreed to instructions, we would do it at noon during lunch hour.
At the court's pleasure.
Okay. But we can continue to go through some of these justifiable homicide and excusable homicide. You also need the two of you, since y'all have agreed on everything, you're going to need to fashion something because the question is going to come up about aggravated manslaughter and those other counts. So it's going to come up at some point. Justifiable homicide, excusable homicide. Any changes in that except for the portion dealing with going down to the bottom, dealing with what may be considered lessers?
I believe yes. No, there are no other changes that I'm aware of.
Okay, first degree murder.
No changes the state's aware of.
Defense. I think, okay, in the first degree murder, I believe that the state had requested the addition based upon certain cases.
Yes, sir.
To be added, the following language: in order to find the defendant guilty of murder in the first degree, the state must convince you beyond a reasonable doubt of the defendant's guilt of either premeditated murder or felony murder. While you must all agree that the state has proven first degree murder beyond a reasonable doubt, you need not be unanimous in your opinion as to whether that finding is based upon premeditated murder or felony murder, as I shall now define those terms.
Your Honor, we would object to that.
Basis of objection.
Basis of objection is that the underlying felony in the felony murder charge is an aggravated child abuse charge. In order to not invoke the merger doctrine here, we're going to have a separate finding. So instead of combining these two issues, we would like to move forward with the standard jury instructions on both.
Thank you. Reply.
Your Honor, I don't believe that counsel's argument responds to the necessity for the instruction. The law, as stated in the cases, is clear that unanimity is not required on the theory by which first-degree murder is proven. So I believe the instruction is appropriate.
Anything else from the defense?
Yes, Your Honor. Because the state is seeking the ultimate sanction in this particular case, we have to make certain that we have a verdict that is reliable. And the merged instructions that the state is offering will call into question the reliability of such a verdict.
Okay. Pursuant to Parker versus State, found at 641 Southern 2nd 369. And Shad versus Arizona, United States Supreme Court decision found at 501 U.S. 624. It meets the requirement. It basically states what the law is. That instruction will be given. All right, felony murder first degree.
Your Honor, as given, 2 sub B states simply attempting to commit aggravated child abuse. Because this underlying felony requires multiple instances or succession of instances, this is an incomplete instruction in this particular case. Your Honor, we propose there should be an additional finding of multiple instances as required under current law and Brooks.
Okay. You all agree as to number 1, Caylee Marie Anthony is dead?
Yes, Your Honor.
Okay. What about 2A before we get to 2B?
2A, Your Honor, calls into the same issue as 2B.
State.
Your Honor, the merger issue that counsel is referring to in Brooks is a legal issue for the court as to whether or not there is sufficient evidence to sustain a verdict for that charge based on separate instances of aggravated child abuse. As the court knows, this is an issue that's in flux in this state, that various district courts of appeal have disagreed that language in Brooks is the law in the state, that constitutes dicta in that opinion. Nevertheless, at the close of the state's case, this issue was argued, and the court made a determination that it was legally sufficient to go forward based on separate or distinct acts, even if, in fact, Brooks says what counsel is urging this court it says. I do not believe that it requires that the jury make separate findings. That issue is addressed nowhere in the opinion, and therefore we urge that the court give the standard approved instruction in this matter.
Yes, ma'am.
Current, as counsel stated and is accurate, this is an ongoing issue, but we have to play them as they lie. Right now, the law is, as related to aggravated child abuse as an underlying felony, it calls in the merger doctrine. So as it stands right now, the law in Florida is that one instance of aggravated child abuse merges into the bigger charge. Second, although the court did make a finding that there was sufficient facts to move forward, that was simply on the judgment of acquittal issue. But this is a factual issue that has to be determined by the jury. This isn't merely an issue of law.
Court will give 2A as written without any additional instructions. Anybody requesting 2B?
I'm sorry, Your Honor, I didn't hear you.
I will give 2A as written based upon my previous rulings when we talked about Brooks and I talked about the case out of the First District Court of Appeals. Is anyone requesting 2B?
Yes, sir. Request 2B.
Defense?
Your Honor, we have the same issue with 2B as we did with 2A. It doesn't require the specific finding of several instances as required under the current law.
Okay, objection will be noted. I will give 2A and B in the alternative. 3A, I don't think the rest apply. Defense?
Agreed, Your Honor.
Aggravated child abuse?
Your Honor?
Yes, ma'am.
In this particular definition, the definition for willfully is lacking.
Just a second. You want the definition for willfully in there?
Yes, Your Honor.
Okay, just a second.
Additionally, 2A, 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 although the state has charged under 16.1, this particular instruction mirrors 16.2 more closely than the 16.1 definition.
What was the stat? Did the state charge him under 827.03 paren 2? Yes, sir. And what are you saying?
That the proper jury instruction under 16.1, this particular jury instruction is more along the line of the 16.2 instruction.
On this is that the instruction as written by the court tracks the indictment and is sufficient.
Okay, in the indictment, do you talk about
Harm, permanent disfigurement, permanent disability. We do not talk about.
you don't
malicious-
talk about aggravated battery, correct?
Well, that is the definition of aggravated battery. However, we don't talk about malicious punishment or torture. I need to see.
Go to 16.1 in the standard jury instructions. Y'all gonna need to make sure somebody bring you a sandwich at noon if you want to get this jury instructed today. That's why I suggested that we come here yesterday afternoon. Have you found 16.1?
Yes.
Yes, Your Honor.
Okay. 1A, do you agree? Anybody asking for 1A? Okay, so you want commit an aggravated battery upon the victim.
Actually, it's 1E is the way it's charged. I apologize. Which I believe is what the court has written.
Yeah, that's what I have written, 1E.
Right, that's how it is charged in the indictment in count 2, with the language that appears in subsection E.
Defense, 1A.
Obviously we think 1A doesn't apply, Your Honor.
That's fine, it's not in the instructions.
Okay.
We don't have any evidence of willfully tortured anyone, do we?
Correct, and that's not charged in the indictment.
Maliciously punished,
Not charged.
willfully and unlawfully caged anybody, do we?
Not charged.
So I think instruction 1 charges 1E, correct? It does. Going down to 2. Victim was under the age of 18 years, correct?
That is correct.
In definitions, besides willfully and child abuse, you want any other definition such as aggravated battery or what a weapon is?
No, sir.
Defense?
Just the willfully, Your Honor.
Okay. False information to a law enforcement officer, and we will get back to the aggravated child abuse, okay?
Aggravated manslaughter?
Yeah, aggravated manslaughter.
Yes, sir.
false information to a law enforcement officer.
Objection to that. Will the jury be getting a copy of the indictment so that they
Yes.
can delineate between the counts?
Rules require that a copy of the indictment goes back.
Okay. Then there's no objection to that.
Yes, ma'am.
We object to this. This particular charge is a case of first impression. It's our assertion that there should be an issue of materiality in terms of the false statements. Additionally, we would argue, Your Honor, that if each instance of false statement should not stand alone, it's one continuing act and should be brought as one particular charge, Your Honor.
Would that not more be an issue for a motion to dismiss at the time before a plea was entered as opposed to now? Which requires that if you do not file a motion to dismiss, the issue is waived.
Your Honor, it's my understanding that a motion to dismiss was filed. I'll have to check to make sure.
And what happened, since I was not the judge at the time?
It was not filed as to these counts. It was filed as to counts 1, 2, and 3. Judge Strickland denied that motion.
I apologize, Your Honor, I misspoke.
Okay. All right. Okay, we will pick this up at where there are less included offenses. Now, two things during closing arguments. Couple of things. There is evidence that the defense can make the reasonable inference of an accidental drowning by the use of the pictures, as Mr. Mason argued. So whether or not one chooses to believe or disbelieve, there is some inference that can be drawn. Anybody want to? So we won't be coming up here arguing about that. So if there's an argument about that, let me hear it now. Hearing none, fine. The next one is there's absolutely no evidence that the defendant was sexually molested by her father or her brother. Now, if somebody sees a different view of the evidence, let me hear those arguments now, so I won't be coming up here to the sidebar.
Your Honor, I would submit that the evidence that a jury can draw inferences in relations to sexual abuse would be, one, the paternity test that was done by the FBI to determine if Lee Anthony was the father of Caylee Marie Anthony. The other inference that a jury can draw would be the fact that Miss Anthony was not taken to an OPJ until the age of 19 years old, despite having, as evidence was drawn in court, that she had her menstrual cycle since she was 10 years old, and that she had an irregular menstrual cycle as well as other female problems as testified to. It is common knowledge that during a gynecological examination, one is asked, and this would also be a child is asked, about sexual activity.
Is there any record evidence of that, since I've never had one of those type of examinations and would not know for the life of me what is asked at one of those examinations? Is there record evidence of that?
No, well, that is common knowledge. I think it is common sense. Just as one can argue that the sun rises, Judge, one can argue common sense and common experiences. In fact, that's one of the things we ask jurors to draw on, their own personal backgrounds and their own experiences in life. Common sense. I think both sides will ask this jury to use their common sense, and that is something that they could both draw from.
Let me ask you this, Mr. Baez. Did Mr. Lee Anthony testify?
Yes, he did.
Did anyone, by chance, ask Mr. Lee Anthony whether or not he creeped into his sister's room, day or night, and attempt to molest her?
Well, I think both sides, for strategic reasons, chose not to.
Well,
May I finish? I have other points I'd like to make.
hurry up because it's getting close to 9 o'clock.
Yes, sir. In addition to that, I think the jury can also make the reasonable inference of the hidden pregnancy, which I think was discussed extensively. And one can also draw their own inferences, reasonable inferences, that there may have been questions as to whether the reasons behind that were because of some type of abuse. There was also evidence elicited from about Miss Anthony's sexual background and her behavior. It's also common understanding, common knowledge that children who are victims of sexual abuse often grow up to become promiscuous and have issues with where the boundaries are of sexual activity, as well as the other behavior that was testified to and in evidence. These are all such as lying, such as compartmentalizing. All of these issues were testified to, and all of them are consistent with someone who has been sexually abused. Now, of course, the state can argue there are other reasons for what it is consistent with, and this is very similar to many of the evidence that came up in this case. There's no more evidence that this child was dealt the hand of chloroform than there is of sexual abuse. I think they're equal. And they ask, both of these theories ask the jurors to draw from inferences. And I think if the jury is going to hear arguments of chloroform or of suffocation by duct tape, of which there also is no evidence of, they could also draw inferences from this type of information. It's not just one thing. It's several things that were shown throughout this trial. And while there were no witnesses, there's also the testimony of Tony Lazaro that stated that they shared secrets. While the secret was objected to and sustained, the fact that they shared secrets, deep secrets, of course, is not. And as the court knows, and as everyone knows, the testimony and the good faith basis that secret has to do with child abuse, of molestation, improper sexual behavior, and incest, we have a good faith basis to argue that secret has to do with sexual molestation. To ignore it, to pretend none of it exists just because someone didn't get up on the stand and actually say it, doesn't make it less. It's equal to what the state's theory is of chloroform. There's inferences, but nobody got up there and said they saw Miss Anthony with chloroform in her hand, or Miss Anthony administer chloroform to Caylee Anthony. So I think to deny that would be denying Miss Anthony a proper ability to argue her defense.
State, do you agree with that?
No, sir. We would take the position that innuendo is not evidence, that there is no record evidence to support any of the inferences that counsel has suggested. Furthermore, there is no record evidence to connect this alleged molestation to any material issue in this case. There's been no record evidence to support counsel's contention that somehow this alleged and unproven and denied molestation somehow relates to what happened in this case. So not only is there a failure of proof of the incident, there's failure of proof of connection or relevance. So we would submit that there is no evidence that counsel should be prohibited from arguing that the defendant was molested by anyone.
Okay, the court hereby finds that there's no facts in evidence or reasonable inference that can be drawn therefrom that there's evidence that either Mr. George Anthony or Mr. Lee Anthony molested or attempted to molest Miss Anthony. Those were the only major issues that I saw.
One clarification, I don't want to run afoul of any order of the court. Would the court restrict the state from pointing out to the jury the failure of proof from opening statement as to that fact? I didn't want to feel if the court, I was running afoul of the court's ruling. I won't go into it, but.
I didn't know you that's
Well, I researched that and I researched it. And the only thing I can find is burden shifting. And the only way that I know that you can go there is if they open the door and make a comment that requires a reasonable counter comment by the state. The burden of proof is upon the state of Florida. I told them
Yes,
when
sir.
both sides got up, opening statement is not evident. So if they remember, they remember. If they don't, they don't. One last thing. This is the instruction that I intend to give them, unless you have something different, dealing with Dr. William Rodriguez. The instruction reads as follows. Ladies and gentlemen of the jury, Dr. William Rodriguez was called as a witness by the defense. Through no fault of the defense or state of Florida, Dr. Rodriguez was not able to complete his testimony. Therefore, you are to disregard his testimony and not consider it in your deliberations. Any objections by the state?
No, sir.
Defense?
Yes, Your Honor.
Yes, ma'am.
We agree with the instructions as you've drafted them.
Okay. Okay, anybody need to take a quick one before we get started? All right. Huh?
2 minutes?
I give you 5. All right. We'll be in recess.